Morning, everyone. Welcome to the November 2nd, 2023 meeting of the Legislative Committee on Administrative Rules. Before we get started here, everyone.
Anthea Dexter Cooper from the Office of Legislative Counsel.
Chris Bragg, representing the Addison Senate District.
Representative Mark Higley, representing the Orleans Memorial District.
Seth Baumgartz, representing.
Good morning, Senator Dave Weeks, representing Rutland County.
Good morning. Representative Carol Odie, representing the far north end of Burlington.
Ginny Lyons, Senator representing Chittenden Southeast.
Mark McDonald, Senator representing Orange County.
Representing Trevor Squirrel and representing Underhill and Jericho. Get started. First item is the minutes from October 19th, 2023.
The adoption.
Do we have a motion? Discussion? All those in favor, please say aye.
Aye.
Those opposed? Motion carries. Okay, first on our agenda today, as far as rules go, is 23E11, Department for Children and Families, expansion of eligibility criteria for temporary housing assistance. Looks like General Counsel Jennifer Micah. Okay, and Nicole, so I don't know who's speaking. Take it away.
Thank you. We have three main changes in this rule. This rule we added language that allows the department to withhold funding in the event licensed lodging is not in compliance with the lodging rules, the Department of Health lodging rules. We have a change that includes increases the age of children who can be counted towards a family to get emergency housing. We increased it from age 6 up to age 18, up to 19 if the youth is in school. And then we made changes to the basic needs standard, which is tied to the reach up standard. And then we changed the way we calculate the income contribution so that it's based on the lowest cost room in the district.
So are these changes from the last emergency rule?
These are an extension of those changes because we needed the extra time to make the changes based on the emergency housing rule as well. So this we've also filed for permanent rules on this for these particular rules.
Any questions from the committee?
Questions, but thank you.
We appreciate the response of the department from both comments and concerns from legislators and committees of jurisdiction and also this committee. I know that both chairs of committees of jurisdiction have both indicated that they feel that this emergency rule does in fact meet legislative intent. Motion?
I had a question. I have to find page 75.
We're waiting for Senator Lyons has a question.
But it was with respect to the 14 days.
It's in the next rule.
It's in the next rule, but there's also some things. It's okay. I can follow up. It's not significant to my approval of the rules. So, there you go.
Senator Bragg.
Hearing that, then I would move approval of Rule 2011, Department for Children and Families, expansion of eligibility criteria for temporary housing assistance.
We have a motion of Senator Bragg to approve the rule. Any more discussion? All those in favor, please say aye. Aye.
Aye.
Opposed? Next up, we have 23E12, Department for Children and Families Emergency Housing Transition Benefit. Jennifer, are you speaking again?
Sure.
Okay.
So we were asked to remove the emergency housing transition benefit from the general assistance rules, which we did. And again, here we added language regarding compliance with the Vermont Department of Health licensed lodging rules and our ability to withhold funds. We clarified that a person who is exited from a motel for breaking rules in the motel, breaking motel rooms could potentially be allowed to stay in the cohort if they are not, if the rules that they're breaking are not a action consisting of certain misconduct, such as violent criminal behavior, nonviolent criminal behavior that jeopardizes the health or safety of others in the motel, or repeated nonviolent criminal behavior would also potentially get you exited from the cohort. So what we're doing now is that we are, if there is an exit from the cohort for a violation of a motel rule, it goes before our operations team and our economic services division to determine whether it is considered an exit from the cohort or not. We also clarified that when somebody has been offered an alternative housing placement, that person may, if the person is offered an alternative housing placement that is in a hospital level of care, they may re-enter the cohort without a time restriction. However, if someone leaves the cohort for an alternative housing, such as drug treatment or physical therapy or something like that, that's not hospital level of care, they may stay out of the motel room for up to and including 14 days. If they stay longer than that, then they will be exited from the cohort. And then I think that's the substantive changes that we made based on the requests of the committee and Vermont Legal Aid, who we did work with. We did also make changes to our to the misconduct form to notify the individuals who are being exited of the reason for their exit so that they can take appropriate action to attempt to be rehoused.
Weeks.
Just curious, the panel that you mentioned that evaluates misconduct, is there a timeline on how long that panel has to meet to consider the nature of the misconduct?
Good morning. For the record, I'm Nicole Tuzian, Economic Benefits Director for Economic Service Division of Department of Children and Families. And
speak up a little bit.
Sorry, that's a mouthful. So when a worker receives a form from a hotel that a client has been vacated for misconduct, that is sent to our central office team, and that's reviewed the same day so that there is no loss of housing or any gap in housing.
So the judgment is made on that day or within 24 hours or so?
Yes.
Okay, thank you.
Representative Hickman.
Thank you, Mr. Chair. Just another follow-up question in regards to that. So if an individual breaks the motel rules and it goes before this board, so to speak, if they were found to have not made one of those more serious issues, are they allowed to stay at that motel, or are you saying that they'd automatically find another placement for them even after whatever the motel rules were, correct?
Right. So that motel has exited the client and we're not able to rehouse them at the same hotel. That's up to their private business rules. But we will find them still eligible for general assistance housing under the cohort and would rehouse them where available.
Thank you for that clarification. Thanks. .
So we had a memo from my cohort in House, Representative Wood, asking a question about loss of housing placement. If someone has lost their alternative housing or housing placement, and then they've been in physical rehab, mental health, or substance use care, a residential level of care, if they're in that residential level of care for 14 days or fewer, once they leave, if they remain in residential care for more than 14 days, they're no longer eligible for emergency housing transition benefit. Can you talk about that a little bit? It's under F, little 2 of 2.
Yep.
And
Yes,
there's just
that
a
is-
phrase, there's also, along those lines, there's a little extra phrase in there, eligible for. Two of those.
Right, so F 1 and 2 is what you're looking at.
Yes, please.
Yeah, so if you are exited, if you have to leave your motel room to stay in a hospital level of care, you may re-enter the cohort at any time after that, up to April 1st, 2024. If you leave for another reason, that's a residential level of care, such as physical rehab, mental health, or substance use, for greater than 14 days, you lose your cohort status, but you may still apply for GA housing under the 28 and 84-day benefits.
So the person moves from the emergency housing benefit to the GA housing benefit.
That's correct.
And what, is there a wait list
Well,
right?
let me just clarify, if they are eligible, they do go through a new eligibility process because there are people in the cohort who would not otherwise be eligible under GA.
And if they're not eligible and they still need emergency housing, then what are their choices?
I think like anybody else, they would have to seek out alternatives like family and friends. And we do have care teams that are out there that may be able to connect with them. But it is a defined benefit. The GA housing is a defined benefit, so it's not open to everybody.
So did this, I'm trying to remember if Act 81 was specific about this or where this comes from.
This is actually broader. Yes, this is broader than the, I hate to use that word. This is different from the statute that was passed. The statute that was passed did not provide a 14-day benefit. The statute that passed stated that if an alternative housing placement included things like nursing home and substance care, but it did not state that you could re-enter the cohort if it were fewer than 14 days. So we have clarified here that you can stay out of your motel room for up to 14 days for those things.
Okay, I'm still trying to understand why this was put in.
Because otherwise, if there would be because the language of the statute, the language of Act 81 states that if you find an alternative housing placement, you cannot come back into the cohort. And so if you left for even 1 day or 2 days to a substance use treatment or physical rehab or mental health treatment, you would not be allowed to come back in under the plain reading of the statute.
Okay, so I'm still not clear why this deviates a little bit from Act 81. If someone was in the emergency housing program July 1, then they're still eligible for the emergency housing program, but this takes them out of it.
I think it's doing the opposite. So if someone were to be placed in an alternative placement, let's say a rehab facility, under Act 81, they would be exited from the cohort because they had alternative placements. And there was concerns that that was too strict, that we weren't giving people who were going to rehab the chance to re-enter the cohort. And so this does that if they're in rehab for 14 days or less.
That's a better justification. Thank you. What we'll do with this one.
Yeah, I guess, so I'm just going to make a comment, then I'll recognize you, Representative Odie. So we're equating hospitalization and other residential care as alternative placement. That's the first part of this, right?
Yes, that was in the statute, the legislation.
Oh, so it's in the legislation as that it's considered, okay.
Yes, it is.
I appreciate that clarification. Representative Odie.
Well, that answered a concern I had, but it seems to me that alternative placement would be meaning, if we have the requirement is that you're in housing, if you were in housing by June 30th, then the state has the obligation to find you housing by April 1st. It may be, how is it that, am I using the terms wrong? They have to find you an alternative placement. The thing is that treatment might last for 3 weeks, and then the person still has to go back and find housing. So is this going to mean that people will leave treatment before they're supposed to, before they're well enough?
The 14 days was intended to address that particular issue.
But 14 days might not be enough. That's my point.
I appreciate that. The language of the legislation is what we're following. The language of the legislation identified drug treatment, nursing home care, and similar sorts of placements as alternative housing placements. That's in the definition of that term.
Thank you.
Any other questions? Ready? Okay. Thank you, Jennifer. Nicole, we have Michael Benvenuto. Did I just butcher your name?
No, that's good.
That's good.
Good morning. I am Michael Benvenuto. I am the director of the Elder Law Project at Vermont Glade. Thank you. I testified on these rules in July, so I was here before the committee. I wanted to come back today primarily to thank the committee for your work on this rule and on focusing on the important public policy issues about providing emergency temporary housing for people experiencing homelessness throughout Vermont in a way that's fair and reasonable and respects their dignity and their rights. So in July, based on the memo from the Committee of Jurisdiction, the concerns that was raised by Vermont Glade through me, you directed the department to make these changes that you're seeing today. And so now we see two different rules, one related to changes to GA and the other for this emergency housing transitional benefit under Act 81. And at the hearing in July, I raised two concerns, one related to the definition of misconduct and the other related to being offered an alternative placement in a licensed facility. We just had a committee discussion about that second part. And I would just to talk about that, I don't know exactly where the 14-day period in the department where they adopted that in terms of being offered a placement. But our concern in each of those licensed facilities, residential care, substance abuse treatment, they're all going to have their own admission and screening protocols. And the original rule in Act 81 talked about being offered a placement within 48 hours you had to accept. And that just didn't seem realistic for a lot of clients who may be considering a nursing home placement, maybe considering going into a different type of treatment setting. So I had interpreted the 14-day period as sort of allowing that sort of like screening and admission process where somebody may be able to go to a residential care home. We see this with our clients for like 3 days to see what they think of the facility. And if it doesn't work, they're not happy there, that they would potentially be able to choose to leave. Now, going back to motel housing, which is not a great option, but people have a right to choose whether they want to go into that type of licensed facility. As I understand it, and I might have missed the whole history, the department put out a memo about that 14-day period sometime in September. So I thought the department was actually doing that before this rule set, which is now adopting that. I could be missing the timing of that. We haven't really been seeing those cases. So in terms of they would have come to the elder law projects, we have not seen clients who are offered like institution, like licensed facilities or alternative placements in those settings and then being terminated. So that's not, we've seen lots of cases, particularly in October, we've had a large number of cases coming in related to these programs, but that we have not seen that issue. The misconduct definition, we did work with the department on that. And so it's a significant improvement in the rules from what was in July, which had no definition at all. So we were reasonably happy with that. By you asking the department to come back in October, that's what's leading to these changes. We did have a limited opportunity to comment on this emergency rule. And as part of our comments, which I think were submitted and committed yesterday, but it's not like you need to look at that. We raised issues in addition to what's actually written in the rule. One is, and Attorney Micah hinted at or mentioned this, was the notice giving to participants. So as part of setting the sort of wheels in motion here, we pushed the department to fix and correct the notice they give to residents when they're being terminated based on misconduct. And they work with us to edit the notice given, and then I would put it up on their website. So we're comfortable with the notice given. That's another significant change from these rules. And the second issue we raised are basically appeal rights, which is in the general assistance program, the rules and process governing appeals is totally confusing and it really should be cleaned up. But by splitting the rules, by splitting the Act 81 transitional housing benefit from GA, it raised the question, well, what rules, process, procedure governs an appeal from an Act 81 termination? The rule itself that you're looking at, the second rule just says, participants have a right to appeal. Your rights will be set out in the notice. So the rule doesn't actually specify at all what type of appeal rights apply. But again, as working with the department in the last week about the notice, now the backside of the notice, which defines the appeal rights, does set out some important provisions, including, which is one of our critical issues, that if somebody's being accused of misconduct and they're being terminated from the program, or they're being terminated from the program for any reason, they have a right to appeal that and continue to get benefits while they're contesting the basis for the termination. And that's, I think, a really important question. We've seen some misconduct cases, but not since the change in the rule, at least that I remember. So in summary, in our comments, we supported a variety of the things the department is doing. We actually think the lodging licensing requirement is a good idea. We supported the misconduct definition that they revised. So we see that the rules are not perfect that were adopted that you're looking at today, but we're okay with them for now. There's still, for the legislature, major issues that are going to be coming up. The Act 81 cohort ends in March. The GA housing program we're hoping for a major reform. And so this is a huge public policy you're going to be facing. So I'm thinking you're going to be dealing with rules governing this population group, as soon as, the next session. So we appreciate your focus on the issue and the work you've done. You've really made a big difference in what's happening now. So thank you.
Ready? Thank you.
Thank you.
Okay, any more discussion? This emergency rule? On a break.
Hearing none, I would move approval of Rule 23E11, emergency rule, Department of Children and Families, expansion of eligibility criteria for temporary housing assistance.
Motion from Senator Bray to approve the rule. Any more discussion? All those in favor, please say aye.
Aye.
Opposed? Thank you. Thank you. Jennifer? Nicole? Okay, next on the agenda, we're just going to have an update, a discussion regarding the fur species rule. We've had multiple meetings now and discussions about the rulemaking from the Department of Fish and Wildlife. We originally had a memo that came from Ledge Council to the department, pointing out some concerns around issues that were in the rule and in the process. And have since gotten a response back from the department with some suggestions about how they might change some things that they were planning on taking to the board at a subsequent meeting, which I believe was last evening. We were then asked if there might be some other issues that they would consider, so they could consider all of these issues at the same time. Myself and Vice Chair and people connected to committees of jurisdiction had met and discussed some additional concerns. And we had Ledge Council help us draft that memo back to the department. And I believe that some of those items were taken up at the board meeting last night. We've asked department's counsel to be here today, and maybe she could give us an update on where we are with things. I will say that this is an update and conversation discussion. We're not voting on this rule today. We won't vote until we get an actual copy of an amended rule from the department, which I assume we'll have for the next meeting.
Yes.
Catherine, please.
Thank you. For the record, I'm Catherine Gesson, General Counsel for the Department of Fish and Wildlife, here on behalf of the Fish and Wildlife Board to talk about the fur-bearing species rule. And last night, the board did meet to discuss some of the items that were set forth in the Legislative Council memorandum, as well as the subsequent memorandum that we received from you, expressing some concerns. Thank you for that. It's helpful to have that feedback. So I thought what I would do, if it would be helpful to the committee, is to just kind of walk through what the board decided with respect to those particular items. And then we can, as soon as possible, I can file a markup and an explanation of where we landed and why. What I'll do is kind of the same thing that I did last time, is start with the trapping rules and go through those, and then go through the coyote rules, and then just talk a little bit about some of the additional items.
Celebrate.
Good morning.
Good morning. How are you?
Sorry to interrupt, but I just want to make sure I get kind of like the process we're in. So there were two sets of memos back to the department and in essence to the board. And then you've now met with the board again. So has the board taken a final position on all the proposals of amendment or questions raised by the committee, or do you still have to, is there another round of interactions between the department and the board to get to sort of a final position?
I think at this point they've taken a position on the memorandums that they received. I wouldn't say that forecloses further discussion or another meeting if necessary. I think the board and the department would like to try to resolve this in a way that's acceptable to Lcar and other members. There are some difficult issues, so I don't know if we're going to get there, but we'd like to try if we can. So I hope that answers your question.
Yes, no, thank you. I just didn't know if we're sort of,
we had
sort of a final step, or there's
Right.
still discussions underway.
We had a pretty short time period to actually consider the second memo.
Right.
So we did address some of it last night, but maybe not all of it. So I don't want to say no, we'll never go back. But I do want to say that, you know, we did discuss some of those issues, and they landed on a place, and you know, if you know, we're certainly open to further discussion.
Thanks for the clarification.
Yeah. So first off, one of the primary issues that was identified in both memorandums was the setback issues, and it started with the definitions of public trail. The board did tweak the public highway. We did sort of amend the public highway language in part because we noticed that the language just focused on town and state highways. And there are some US highways that are in Vermont that are very similar to state highways, and that could be confusing for people. So we added US highways in. They also are mapped by the Agency of Transportation. Route 7 is an example. Like, how would somebody necessarily know the difference between 107? So the setbacks would apply to those as well. With respect to public trails, the initial language was focused really only on a pedestrian footpath on Vermont state lands. That definition has been significantly expanded to include all non-motorized recreational purposes, hiking, walking, bike riding, horseback riding, all of those activities that have been designated and mapped by municipalities, state entities, and federal entities. In addition, a new definition was added to include a path or a corridor with similar recreational opportunities for those paths that are designated, managed, and maintained and clearly marked on the ground by on municipal land, state land, and federal land. So that was kind of an attempt to try to define the catch-all path, trail that was requested in the latest memo. The board approved the addition of the Vermont Rail Trail, which is mapped and managed by the Vermont Agency of Transportation, the Appalachian Trail, and the Long Trail. So those are all included in the public trail definition and would be subject to setbacks. So with that, I'll just kind of go to the section that really imposes the setbacks to legal trails, public trails, and public highways. And that language was in 4.5 of the regulations. And the draft that the board approved essentially applies the setback of 50 feet to legal trails, public trails, and public highways. The exemption regarding being set in the water or under the ice is still there. And the board also approved a limited exemption for wildlife management areas. Directed, essentially, the language states that that the department can designate certain types of trails as being subject to setbacks, as well as in that process, the department would have to also put up signage and notify the public of when hunting and trapping seasons are occurring and where setbacks are applicable. The second part of that rule is that there would be a setback of 100 feet from infrastructure that is on parks, playgrounds, schools, camps, picnic areas, shelters, visitor centers, wildlife viewing areas, pavilions, schools, campgrounds, and recreational facilities. So it's a fairly broad group of recreational facilities that are owned and managed by, municipal, federal, and state entities, so on public land. So that's sort of that. And I can take questions about that if you want, or I can just sort of walk through the whole thing, and then you all can.
I think as you're doing your presentation, committee members, if you have questions. I think nobody's shy here, so.
Sure. Of course not. So the only other, the other section of that had to do with trapping that was mentioned, I believe, in the Legislative Council memorandum was the dispatch of, well, actually, we did change or recommend some changes to the dispatch of trapped animals. We added a carbon dioxide chamber because that is a methodology that is in compliance with the American Veterinarian Medical Association guidelines. There are other mechanisms or that are considered humane by that organization, but they are very situation and species specific, so that can be a very complicated analysis. So for example, lethal injection involves either taking the animal to a veterinarian that has a certification to do that. But that was a sort of a broader mechanism that was considered to be humane in every situation. So we added that to the dispatch of animals along with, sort of the traditional gun. And then we, because there seemed to be some confusion about the idea that we would come back and make recommendations related to dispatch based on recommendations from the Agency of Fish and Wildlife, the Agency of Fish and Wildlife Agencies, Association of Fish and Wildlife Agencies, we crossed that off because we'd have to come back and do rulemaking anyway. And so if we do receive those recommendations, we would eventually come back to the rulemaking process. We also included some clarifications of the reporting requirements. The reporting requirement language for biological collection was somewhat general. It just required people to submit a trapper survey. So we tried to make it more explicit and indicated that except for persons who are exempt by statute, any person who traps any animal and obtains a trapping license has to fill out that survey, including reporting the taking of incidental animals. And we also included language that's consistent with the statutory provision that requires trappers to report trapping a dog or a cat within 24 hours of discovery. So that's it for the trapping section. When we got to the coyote section and control of dogs, the definition of control of dogs, we did try to clarify that language to make it clear that at all times during the training and hunting or taking of coyotes with dogs, that a permittee must have the ability to both locate a dog and recall the dog. And We included some clarifying language in the directive section related to that, which is the section that kind of really lays out the requirements for legal methods, for taking coyote, as well as when folks are hunting. And so making it very clear that the control collars, the GPS functions, the track log capabilities all have to be included and on the dog while they're hunting. This issue, I think, is a difficult issue for us, and I understand, that the legislature has expressed concern about control of dogs. The idea that we would impose a condition that a hunting dog would be either on a leash or within sight is something that we felt that we couldn't support, because we felt that it was a de facto ban of that activity, and that eventually these standards will be applied to all forms of hunting with dogs if we were to go in this direction. And we do feel that it is a important wildlife management issue, particularly for bears and the conflicts that we have with bears in the state of Vermont now. We have a very healthy, abundant population of bears, but we have burgeoning conflicts, and just the numbers of calls that we get about bear conflicts are rising. And we think that this is one tool that can really help keep these important wildlife resources wild, which is where we want them to be. It's wild and wary of people. So that might be one where we need to have some continuing conversations, but that was where we landed last night. So, and then finally, I think there were just a couple of other sort of clarifications. There had been a removal of poisonous mixtures. We added that in with, we combined that with explosives, chemicals, and poisonous mixtures, and then put in the exception of the carbon dioxide chamber used in dispatch in accordance to the recommendations of the American Veterinary Medical Association. And then finally, there was one correction that we made that really wasn't the subject of a memorandum, but had to do with the lottery system for, we're capped at 100 permits for coyotes by statute, and the language around the lottery was not exactly clear. So we just tried to clarify that language so it was clear what our process would be, that we would undertake a random drawing if applications exceeded that number. So I think that's it just for the overview. Thank you.
Thank you.
Just make sure.
I just a quick question before I open it up. Questions. Maybe we made a number of suggestions to the department for consideration, and then you presented those to the board. Did you present all of them, or did you make some decisions at the department? Which ones?
We provided the board with the legislative initiative. We did not recommend that the board, although we were very clear that the control of dogs was of concern, we did not make a specific recommendation that they incorporate the suggestions that were in that memorandum. And we basically expressed concern that it would be a ban on that hunting, that form of hunting. So the other issue that we did not address with the board was the definition of hunting trapping as a form of hunting. But the other, the board actually had a pretty robust discussion about the traps underwater. And the vote was very close, actually. So.
The reason for not taking up the definition of trapping, or at least giving the board the opportunity to have that conversation?
I think the consensus was that we feel very strongly that trapping is a form of hunting, that this does not infringe on the constitutional issues, that it does not infringe on the legislature's authority to regulate trapping or to ban trapping ultimately, but that definition is very consistent with the history of trapping, with the history of hunting, with the history of the Constitution and the language of the Constitution at the time of its passage.
Did Act 159 ask you to consider that?
No.
What was your question again? I'm sorry, Chair.
Did Act 159 ask the department to consider that?
Thanks.
Sorry, I'm not. If you can't hear me, ask me to speak. I should be soft. Anyway, I want to open up the committee for discussion and questions. On a break.
So thanks for the last bit on the definition of hunting. And not to, I think just by way of explanation, well, the memo speaks more precisely than I can, but I think some of the concern was the implications of defining trapping as hunting because of legal implications that follow from identifying an activity as hunting. So, but there'll be more to follow. I wanted to follow up more on the control of dogs portion. And today I think you said that you recognize that the goal was that permittees or hunters must have the ability to locate and recall dogs at all times. And one of the concerns is based on a decade of experience with these kinds of collars that my personal experience has been, so just one, but I've talked to many other people who work with hounds and in the field, and you can locate them, or that part's pretty straightforward. They can be very distant from you. They may be 5, 6, 7 miles, maybe even more. But when you say that, and to recall at all times, I'm not sure that any device, particularly one on a hound that's so remote from the person with the tracking device, the control device, can reliably assert that they are able to recall a hound. Toning doesn't necessarily lead to a predictable response, particularly so my real world experience is the further away they are, particularly if they're in a pack, the device may work reliably, the hound's response to any sort of toner shock becomes less reliable, predictable. So from the point of view of saying being able to recall a dog at all times, I don't think it achieves that. That's what's behind my contribution to the discussion with my colleagues that led to that part of it.
Yeah, I appreciate that.
I think that there was the language in the memo also that there's the go to it, and that was there's a phrase in here about what, sort of possible reformulation that refers to in visual sight under voice control or both. And, so to be fair here as well, I think there's voice may be more limited than what tools people use in the field. They may use voice, they may use a whistle, they may use a horn, but it is a direct connection to that, communicating with that hound. And in part, what helps is that you're relatively close when you can use those tools. Just offering that additional explanation.
Thank you.
So
Yes, thank you.
I have Representative Bongartz and then Senator Lyons.
My question was around in the memo, we asked the board to consider the trail rule closer to what Massachusetts and New Hampshire has. And did the board consider that? Which isn't necessarily mapped, but just what is in fact a trail?
Correct. What we landed on was, in addition to the mapped and designated, was something that's clearly marked on the ground. So it doesn't necessarily have to be mapped, but there has to be some signage, some sort of a blazing tag, signage, et cetera, and marked on the ground. So that's what we landed on, is more of a, and that, I think, most state and federal entities have really good resources where they have mapped and designated trails, and they have great, websites where you can go and you can get information where trails are. I think the difficulty is where there are municipalities where they may have trails that they have blazed. They've got like a kiosk with a sign. It's clearly a public trail, but they don't necessarily have a rec department and they don't necessarily have maps online. This would cover that kind of situation.
That's still different than what New Hampshire and Massachusetts is.
Correct. And part of this is that we really think it's important that this be enforceable, that people understand where these setbacks are, what is a trail and what is not a trail. Not only for the public, but for the trappers. And so, and for enforcement. I mean, if a warden, is called to look at a situation where a trap is, on a logging road, is that really a trail? There has to be some kind of definition in order for us to administer this.
Thank you. That's a couple of questions about the control of dogs. You brought up bears, and so coyotes are one species and bears are another, and certainly training is different for those, and recognition of the dogs with the coyotes is different from a dog recognizing a bear. But is there a difference between the process and the regulations around how dogs are used in bear hunting as compared with the dogs that are used in coyote hunting? What is it? Can you talk a little bit about a distinction between those two?
What I can talk about is the coyote rules are based in large part on the bear hunting rules. However, the coyote rules have additional requirements. There is no requirement for GPS collars, for logs that track where the dogs have gone. There's no requirement for, training collars, a tone or a shock to a dog in the bear rules. The other thing that's quite different in the bear rules is that in the bear rules, Sub-permittees have to be within sight of of the permittee. And we decided that that didn't make sense because it would prevent people from communicating by, radio or cell phone or other means. And that it's easier for folks to kind of spread out and kind of follow the dogs where they're going. If they have the track logs, they know where they are. So if usually folks do hunt together. And so having people so that they can communicate while the dogs are, they're running through field and forest. So it's after a wild animal. So they can be moving pretty quickly. I do think that there are probably a number of hunters that are going to have to engage in more intensive training. They're going to have to buy new equipment. They're going to have to make sure that they've got data on their GPS that signifies where where there's posted land. Because part of the statutory provision is that these dogs are not allowed on, it's a violation if they go on posted land, and it's also a violation if they go on land and they've been previously notified that they're not welcome there within the last year. So they're going to have to know where those dogs are in relation to properties that are posted and places where people have said, we don't want you on our property. So they're going to have to retrain to some extent.
Was there any consideration of having additional fines or penalties if dogs go onto land where that's posted or where they've been told they're not wanted?
That was part of it. There are penalties associated with that. I don't know if there would be additional. That would be a statutory provision. As part of Act 165, the department did suggest that there would be a penalty for allowing, so that was part of the proposed language that was part of 165 that we supported and that we actually recommended, I think, is to allow the wardens to, charge somebody with a violation if they allow their dogs to go on posted property, and the other one too. So those provisions wouldn't kick in until the rule was passed.
Also. Representative Higby.
Thank you, Mr. Chair. I guess first I'd like to start out with thanking the department and the board for their efforts in answering questions that came from some members of Lcar. I talked to the chair about this a little bit and talked to Ledge Council as well about my belief how important it is for a sign-off sheet, which Senator Lyons signed off on one of the last rules in regards to whether or not the chairs of the committee check off whether it's contrary to legislative intent, beyond the scope of statute, arbitrary, or the final one meets statutory requirements. I never saw this for this particular rule. And to me, someone who's not sitting on that committee, it's important for me to see this so that I can maybe understand how there may be more questions that come up. I think it's unfair in a sense to continue to ask questions or have the board answer specifics in regards to what any individual Lcar member wants to see happen. I realize, and I was a little upset with the last and even the previous iteration of what was going to be considered without my knowledge. I understand that's fair game. Let council explain that to me. And unless I speak wrong, let council can correct me, but I also have the opportunity to do that myself, express whatever it is that I feel that goes out on Lcar letterhead. I don't know as I agree with that completely. I feel that it's important for all board members, all Lcar members to understand what's being asked of a department or agency or a board. So again, I'm a little disappointed there. It sounds like this could continue to go on. I hope that we wrap this up by the next meeting on the 16th, I believe. There is a moratorium, my understanding, currently. I think it's important to move forward. And in my personal understanding of some of the latest questions to the board or examples of what they may like to see, it's unrealistic. I believe it is a de facto ban. I know for a fact, I don't currently have hounds, but I have in the past had hounds to run rabbits and raccoon. It is totally unrealistic to think that you're going to have voice control or visual sight or both when you're hunting with hounds. And that to me is unrealistic. I appreciate the board's position on that. And, you know, if a ban is what's being looked at, then the legislature needs to step up and put that forward. But I don't believe that's what happened. So anyway, I want to appreciate what the board has done, and I hope we can curtail any further issues in this regard and move on with the rules that are look at the final rules that are presented by the department and have a vote. Thank you.
Senator Lyons.
I just want to go back to a earlier comment that I made, and that is that training dogs to follow coyotes, which is a very similar species, might engage those dogs in following domestic animals, dogs. Training dogs to trail bear or other species is different. And so I'm not on the committee of jurisdiction. I don't know whether you've talked about the differences between how hounds are used for different species and what the outcomes are for that. That would be very fascinating to know, including, you know, fox, you know, how close is that to the coyote or the domestic dog? So just a question and a thought that fits in with the issue around sight and sound.
I appreciate that question, and that's not really my area of expertise as legal counsel, but I certainly can ask, staff to try to address that question when we file a response and file the markup so that, the committee has that information. I appreciate it.
Great. You all set?
Oh, yeah.
Thanks. So I want to thank, as I often do, Representative Higley for bringing up, helping our discussions in Lcar. And also, although I didn't start with it, I want to say again, thank you to Guessing and the staff. We've had numerous, I'd say, very cordial, productive communications and on a difficult and controversial topic in the last 6 weeks, whatever it's been. I also had the concern about one of the things that I wanted to be sure we were not doing in writing a letter and sending on additional areas of concern to members of this committee or including the chair of the House Committee of Jurisdiction, I said, well, I want to make sure that we're being fair to them, like sort of a speak now or forever hold your peace. And I was concerned about that because we'd already had a memo from Legislative Council, sort of on behalf of the full committee. But that was a very helpful memo, but it also went before we had ever convened as a committee and spoken directly to the department. So the second letter that came from individuals on Lcar and the chair of House Energy and Environment was, from my point of view, the product of learning more about the rules based on the discussion that we had and the presentation that we had in Lcar. And that was, so for me, that was a sort of speak now, forever hold your peace thing, which I think is fair. But I think that's why I wanted, as I said it when I was talking with colleagues, I don't want us to be in any way sort of moving the goalposts. It is that there was an initial letter from council, and now there is a complimentary letter from the committee. Thanks for raising it, and I hope that those who are in the department and on the board or observing feel like we've been careful and fair-minded about how we've communicated around the rule.
I will say that having, the board as the rulemaking authority does make it more complicated, I think, both for Lcar and for us. And, we have consistently asked for input, and we do appreciate it. We may not always agree, but we do appreciate the conversation, so.
Ready? Senator McDonald.
This is perhaps a picky question, but we keep talking about dogs. And there are hunters that have pointers. There are hunters that have retrievers. When we've been talking about dogs today, we've been talking about hounds. I guess it's a question for all of us.
Yeah, I do think that most of the dogs that are used either for bear hunting or coyote hunting are usually hound breeds.
And people,
Yeah.
dogs are used to follow criminals, they're hounds. So perhaps we should use the word hounds instead of dogs at a public discussion like this, so that those watching and listening know what we're talking about. I'm set.
Just to be clear about this, when hounds are 5, 6, 7 miles away, you're tracking them with GPS. Can the person whose hounds they are actually tell what they're doing? They can tell if they're running, I guess. Can they tell whether they have surrounded a coyote or a domestic dog, or what?
They can tell if they pause, they can tell what their location is, they can tell kind of what their speed is. They can also tell if they're packed, in other words, if they're just, because they have to track each dog, not just one member of the pack. They have to track each dog so they can tell where the dogs are in, where their locations are with respect to each other.
And what circumstances might they? I'm just trying to really understand, because this notion of control was central to the legislation, and I'm trying to understand if there are ways that the person who's in control of whose dogs they are, the dogs are some distance away, can actually tell. I get that they can tell if they're running or if they are packed, but what does that actually necessarily tell the person whose dogs they are about what they're actually doing? Is there any way to know whether they're doing something that is legitimate under what the rules say or not?
Yeah, I'll get that answer for you. I can't really answer that question.
That's that was so central to the discussion in the committees. So.
Any other questions? So we'll have something from the department on the Monday prior to our next meeting, which I.
Definitely by then.
Yeah, so it'd be I can do math, the 13th, by noon on the 13th of November.
December.
November. Yeah, so your next meeting is in 2 weeks, and under your procedural rules, your deadline for something to consider at that meeting is noon on the Monday before. So for a November 16th meeting on Thursday, it's noon on the Monday, November 13th. We'll send that out as soon as we get it in, even if it's before the deadline, and it certainly will go out before Charlene's Tuesday.
So we'll have something, we'll have a rule from the department, a modified rule of some kind. And it's my plan that we'll we've had a lot of conversation, discussion around this, and it'll be time for us to make a decision, I believe. We have one other. It's a 7-part rule,
Yeah.
right? I think right now, I'm considering making it a 3-hour meeting just to give ourselves time, so in case we need that time, but I haven't made that decision yet. I'll speak with council, we'll try to figure out if we can fit it into 2 hours, but think about that and plan for that, 10 to 1, just in case. Any other questions, comments? I do appreciate your willingness, Catherine, to be involved in this process and for the department. It's not an easy process, for sure. We all have our own feelings around these issues too, but we also have responsibility as members of this committee to look at the rulemaking process and from the legislative intent, things like that. That's our job to do that. So with that,